So today we're going to be talking about trademark opposition. So the process of registering a trademark involves two kind of main phases. The first of these is the trademark examination, and this is when at the Intellectual Property Office an examiner takes a look at the kind of application for the trademark to make sure that it can function as a trademark and it's all within legal parameters there. And the second phase is what we call the opposition phase. This is where the trademark is published onto the trademark journal and becomes publicly available for people to have a look at, this kind of prospective trademark. And at this point, as it is of course, as we mentioned, the opposition phase, it gives the opportunity for existing rights holders to potentially oppose the trademark registration, which is to say, stop the registration from going through and for that trademark to be registered. So it's really, really important for people when they're looking to register trademarks to understand how oppositions work, look to be able to understand how to avoid it in the first place, but also know how to deal with them when they do pop up. So today we're going to be talking a little bit about that. Okay, so first and foremost, what is a trademark opposition? So trademark opposition, as we've kind of previously described, offers existing rights holders the opportunity to prevent a trademark from being fully registered at the point when it's published. And what's more, this opposition can oppose elements of that trademark in terms of certain classifications or parts of the specification, or it can actually oppose the entire trademark being registered itself. And there are certain grounds which this can be based on, legally speaking, so we'll just go through these in just a second. The first ground is possibly the most kind of well known, and this is to do with whether the trademark is identical or similar to an existing trademark which is also operating within identical or similar goods or services. So for example, if you are manufacturing shoes and you decide to put a tick on the side of your shoes, Nike, for example, may oppose your trademark registration insofar as you are using an identical mark which they already have registered for the same kinds of goods. So this is one of the more kind of obvious ways in which trademark oppositions can happen. The second ground for a trademark opposition is whether the proposed trademark registration is contravening of the reputation or is detrimental to the reputation of an existing mark. So for example, you might find that if you are parodying, or if your kind of proposed trademark is kind of deliberately bashing the reputation of an existing brand, that an opposition might be forthcoming. The third ground is whether the trademark registration is actually contrary to law. So this is to do with kind of existing law that's on the books as it relates to perhaps unregistered trademark rights, kind of understood through the laws of passing off, but also kind of other laws that exist which would kind of stop the trademark from being registered. So again, for example, as it comes to passing off, there may be a fairly established brand in the area which actually doesn't already have a trademark. However, they might have such a reputation where they would actually be able to, through the law of passing off, kind of oppose your mark from being registered in that way. The fourth ground for opposition is actually to do with whether the trademark can function as a trademark. And this is quite interesting because, of course, during the examination phase, oftentimes these kinds of things are picked up by the examiner before the trademark's published. And this is whether the trademark, for example, is very descriptive, or if it kind of uses terms that are typically used in the course of trade, which other kind of operators within that space would and should be able to kind of identify themselves as. So for example, if you are a plumbing services company and you call yourself plumbers, perhaps, perhaps even not stylized in such a way, you would be on having the trademark for the word plumbers, stopping anyone else in the plumbing industry being able to use that word, which of course would be kind of nonsensical in a way. So there's an element of which the trademark has to be distinct of the kind of things that are involved in those goods or services. And what is interesting about this as well is that all of the other grounds that I'm talking about today in terms of how trademark opposition can be brought can only really be brought by an existing trademark holder who is essentially asserting their rights, or indeed if it's a trademark holder, it could also be someone with other rights such as the right for passing off. However, with this particular one, anybody can actually oppose your trademark application, simply because this is more to do with the kind of fundamental law about what can be registered. And finally, the last main reason, kind of grounds for opposition, which we're going to be covering today, is what we call bad faith registration. So bad faith registration kind of covers the idea of somebody perhaps looking to do what we kind of in common parlance call trademark squatting. So for example, there might be a brand that's kind of on the up and up and would probably look to register its trademark. Sometimes you'll get kind of IP or trademark trolls who will then seek to register that trademark before the legitimate business who uses that name, simply perhaps to hold that trademark and maybe try and sell it to the company. This is known as bad faith registration because essentially the company that's looking to perhaps pinch the trademark ahead of time is doing it not because they are looking to actually operate using that trademark, but more so because they are looking to kind of get one over on the prospective legitimate owner. So you do often see these from time to time, kind of bad faith registrations. And again, it often also happens in the online space, but that's not so relevant here. But yeah, again, bad faith registration, people will be able to oppose those. So, at what point can a trademark opposition occur in the process of registering a trademark? As previously mentioned, essentially what happens is that once the trademark is kind of applied for at the relevant intellectual property office, at some point during that process, the opposition period occurs. And what that essentially is, at least in the UK, is a point where the proposed trademark is made public and is published in what we call the Trademark Journal. In the UK, this is a 2-month period, which essentially allows for people to have the opportunity to oppose the trademark. So from the date of publication, there's typically around a 2-month period, which was known as the opposition period, where existing rights holders and holders of trademarks have the opportunity to oppose a trademark. In essence, this essentially alerts people who have monitoring or watching services out there of, trademarks that are kind of in the offing, and it gives them that time to kind of decide whether an opposition is the best course of action, and whether these trademarks are kind of encroaching upon their existing rights. Now, this 2-month period can actually be extended by a single month as well, by the filing of a notice of threatened opposition. So this is a kind of formal interaction with the procedure of registering a trademark, which essentially grants that extra month, wherein, usually speaking, a negotiation begins to occur between the proposed trademark kind of registrant as well as the existing rights holder. Now, the kind of filing of a notice of threatened opposition doesn't actually kind of beholden you to then follow through with the trademark opposition. It just gives that little bit of extra time for that discussion to happen. And typically what we do at Virtuoso Legal in such circumstances is kind of weigh up the commercial goals of the client who we're representing, whether they're opposing a mark or they're having their mark opposed, and look to secure that with the least fuss possible. So yeah, it's quite important to be aware that during the process of registering a trademark, if opposition is a possibility, that there may be some interaction with other kind of trademark and existing rights holders at some point. Finally, it is also important to notice that should this notice of threatened opposition be filed and that an extension of a month is added on to the kind of publication window and the opposition window, that this extension only applies to the person, or the parties rather, who have extended it through that filing of the notice of threatened opposition. So essentially, only can that extension can only really happen if that interaction's happened. So if you're somebody who would like to have a bit more time to kind of look at whether you should be doing an opposition, and somebody else has extended it, that extension doesn't actually mean anything for you. So again, it's important for somebody, if you're looking to oppose a trademark, to kind of act decisively and to also be very kind of quick and aware of your rights and what you're trying to do. So again, it's always best to speak to trademark professionals when doing so, to ensure that your commercial best interests are secured in doing so. Okay, so what should you do if you receive a trademark opposition for your filing? There are several different kind of approaches. Again, as previously said, when you're going into the trademark application process, it's very, very important to be aware of all of the things that can fall out of that process, and a trademark opposition is one of them. However, should you receive a trademark opposition, the main thing to do is to not panic, because there are several different solutions to this, which we'll go through in the following kind of sections of this video. Okay, so one of the first things we look to kind of negotiate typically is what we call a coexistence agreement. So a coexistence agreement is essentially a kind of negotiation that occurs between two businesses who are looking to kind of secure a set of trademark rights. And what we look to do here is align the interests of both businesses. This might mean that if, for example, we are representing the person who has applied for the trademark, maybe we'll be looking to adjust the specification or the classifications which have been applied for to make sure that nobody's treading on each other's toes. So this is essentially a very commercial negotiation, which requires an expert approach and also requires the right kind of diplomacy to make sure that everybody comes out the other side happy. As always, it's very, very important to make sure that you have expert advice in doing so. When you are in any position where you are kind of essentially assigning legal rights and restrictions upon your business or other people's businesses, you're going to want to make sure that that's done properly. You're going to want to make sure that you don't essentially kind of sign the crown jewels away, and that essentially your commercial interests are secure. We've seen it before where people perhaps limit their trademark specification after receiving an opposition and essentially entirely devalue and limit the scope of what they actually have cover for. And in a commercial sense, this means limiting your business activity, which means limiting your revenue. So again, if you're ever in that position where you're applying for a trademark and you think there might be opposition, or indeed you've received an opposition, definitely get in touch with intellectual property specialists such as ourselves, who will be able to make sure that you get the best possible result out of that process. The second option for a trademark applicant in relation to an opposition is essentially a defence of that application. So defending an opposition is essentially a kind of formal proceeding which is much more involved than the kind of negotiation we were talking about before in terms of coexistence. What this entails is the filing of a defence in an official manner to the Intellectual Property Office, and for this to be kind of examined again by the same. During this time, typically it's very difficult for a defence to be submitted within 2 months, so there's often an extension of this time with what we understand to be called the cooling off period, which adds an additional 7 months to that 2 months, so totaling 9 months. This itself can also be extended by a further 9 months, totaling 18 months if necessary. However, again, during this phase, there's typically negotiations between two sides. It can be slightly acrimonious, otherwise a coexistence may have been reached previously. And essentially, you're going to want to make sure that once more that you have, experienced and expert kind of trademark professionals on your side. You understand exactly where the line is in terms of what you can look to defend, and essentially aligning what you're looking to achieve commercially with that process. Of course, nobody wants a delay or added costs to the process of undertaking defense of a trademark opposition. However, again, this might be a key brand for you, and you may require, once the cost-benefit analysis has been made, to do so. And again, you're going to want to make sure that you're very, very successful in that case. It should not be understated as well that once you enter the defense of a trademark opposition, should you lose that case, that you may be liable for costs, and that's something which you're going to have to be very, very clear on at the outset of kind of defending. So again, speaking to a trademark professional will give you a kind of prospect of the success of a defense, to make sure that you're not going to be wasting time or money in that position where you might potentially lose that and then have to go back to square one. So again, very important to make sure that if you are defending your trademark opposition, that you're very clear and you're very confident that this is worthwhile when you look at the kind of cost-benefit analysis of doing so. Finally, the last path that you might take when you receive a trademark opposition is essentially a withdrawal of the trademark application. Now, nobody wants to kind of do that, but essentially it saves you the kind of prospect and the kind of the problem of trying to defend the indefensible. You know, upon expert review, you might find that there's just no way that this trademark is ever going to be registered, or that you'll ever be able to reach an agreement with all the other kind of relevant parties. And in doing so, it just allows you to kind of start again from square one, but in a way which, you know, you can move forward and kind of come to like a new brand that's much more distinct, much more kind of protectable. Ultimately, these are always kind of scenarios in which it's probably better to kind of nip it in the bud, because again, if a brand is kind of being opposed quite strongly from the outset, it's probably going to have a very kind of a limited kind of distinctiveness in its marketplace anyway, and it's much better to kind of from the outset develop really, really distinct and unique brands that kind of stand out and that have their own kind of singular presence. So again, at this point, you kind of look at starting from square one, from the proverbial blank page, and to develop a new brand that's really going to have that impact on the buying public. And in the next section, we're going to talk a little bit about how this is achieved as we talk about how to avoid kind of trademark oppositions in the first instance. Okay, so how do you avoid a trademark opposition in the first instance? When approaching the idea of registering a brand, it's very, very important for business owners to really consider the process of branding or kind of developing a brand as an opportunity to carve out a kind of unique territory in the mind of the consumer. This requires an emphasis on like brand creation that's unique, that's kind of, you know, arresting of the attention, and that is, you know, you don't really want to fit in amongst everyone else on the shelf. You want to kind of stand out in the best way possible. So we're going to look at a few things which you're going to be needing to do, both in terms of your brand development, but also in terms of ensuring that your legal footing is best placed to do so. So we'll start to talk about that in just a second. So first and foremost, you're going to want to develop your brand with uniqueness in mind. One of the things that we often see is that people kind of come up with an idea for a brand, and it's something quite personal, and it's something that's not necessarily thought of with distinctness in mind. It's perhaps something which, you know, they have a personal bias towards, or, you know, they haven't really looked at in terms of the kind of competitor analysis or the understanding of the marketplace need. So from the outset, you know, a lot of people are missing that opportunity of thinking, you know, you could imagine yourself on the shelf at a supermarket. How do I stand out to the eye? You know, how do I say something a bit different from everybody else? Because at this stage, when you're in your brand development journey, it's such a missed opportunity to not think in that way and really kind of make an impact in the mind of the consumer. And in doing so as well, from a legal point of view, you're much less likely to be bumping into anyone else's shoulders or stepping on anyone else's toes from a brand perspective. So take the time to work and to really kind of like think outside the box. Even though that's a bit of a cliche, in doing so, you'll probably find that you'll be less likely to come across trademark oppositions, because simply put, you don't look or feel like anyone else from the outset. So the second step to avoid a trademark opposition would be to adhere to the advice that's out there. So make sure that when you go in the process of, you know, registering a trademark, that you take a look at the guidance that's out there on the intellectual property website. There's lots and lots of information out there on the internet. Take it all in and just make sure that you're not going in with a blindfold on. Again, watching a video such as this one will be, helping you along in that journey. But it's not something to do without having done the prior research. The proverbial golden ticket when it comes to avoiding a trademark opposition is a professional clearance search. Most business owners, when they register a trademark, will of course have a look on Google, and they will of course have a look in the trademark registry as it relates to kind of pre-existing marks that might cause a problem. However, a trademark professional has the expertise and the experience to really understand what level of risk would be involved, and organisations such as ourselves have specialist software that kind of produce these risk registers, which would kind of give you a much clearer idea of whether or not an opposition is going to be received, who it might be received from, and the kind of level of which negotiation might take place. So this gives you, that kind of peace of mind of kind of being able to predict what might happen when the trademark registration goes in. And of course, those that self-file often find themselves surprised at, how many oppositions they receive, the kind of, the aggression perhaps of the other side in terms of enforcing their rights, and they're not necessarily very clear in terms of, what to do next. So again, a professional clearance search will let you know if that brand's kind of clear to land, and again, it will have you prepared for anything that might come up. Finally, how do you oppose other people's trademarks? So again, as we've spoken about before, other people's trademarks are being published in the Trademark Journal every single day, and you are essentially, made aware of them by kind of keeping an eye on that journal. Now, what we do as a firm is we offer what's called trademark watching, or kind of trademark monitoring, where if you kind of speak to us, or indeed other people who offer the same service, they keep an eye out for things that might kind of come up as and when, and alert you to that as and when they do, so then it gives you the opportunity to kind of review the proposed trademark and then perhaps oppose it. Again, that has to happen within that 2-month period at the point where it's published. So brand owners that own many trademarks and that are looking to really kind of strongly enforce their rights and kind of maintain that unique kind of brand territory in the mind of the consumer will always be wanting to keep an eye on that, either through a monitoring service such as our own, or through other means, and they'll need to be ready to act as well to oppose trademarks. Of course, if you don't do this, what happens is slowly but surely the uniqueness of your brand is kind of encroached upon by other trademarks that start to appear and just take little bits and pieces away from that distinctiveness.